My Lords, my Lady, I appear with my learned friend Mr. Sutherland on behalf of the appellants. My learned friends Mr. Roy Martin and Mr. Alistair Bennett appear on behalf of the respondents. My Lords, my Lady, you have the agreed factual matters and the chronology, the statement of facts and issues in the parties' cases. I take them all as read, unless there's any issue which you immediately wish to address.
No, we're very grateful. We have had the opportunity to read them, and we've taken advantage of that opportunity.
Excellent, thank you. May I then deal with some orientation to start with, so that my Lords, my Lady, know what we're talking about, and refer for convenience to two additional plans, which I understand you may not have seen before, despite our best endeavours, but which were provided this morning. May I hold them up? Without the red ink, they look like that. Mm-hmm. You were provided with additional copies this morning, I hope.
Since there are quite a lot of people in court taking an interest in these proceedings, perhaps you could bear in mind that they haven't got the plans.
I will. And may I say the only reason for producing them, if the court has to hand the appendix part 1,
yes,
within which is the strategic development plan, and if you go to page 46 or MS 174.
174.
174.
Yes, if you give us MS numbers, that'll be fine. Yep.
Yes.
Thank you.
You'll see there, and
of sorts, yes.
Well, perhaps I don't need to say much more. If you turn through the plan to the next page, or next but one,
the sort of thing you might expect to see in an art gallery rather than that.
And then for even more delectation, page 50 or MS 178.
Yes.
You will see, and there is a plan then of a similar kind for each of these strategic growth areas in the SDP, and in order to allow some attempt at deciding what the plan shows, MS 215, page 87, there is a key.
Yes.
The faintest tinges in colour affect what one's seeing on those plans, and with that in mind, and not being anxious to spend a lot of time worrying about whether something was a pale shade of coral, cream, or white, we've produced these additional plans, and what these additional plans show is, in effect, what the strategic guidance we're here concerned with is focused on. And so the first, that is the coloured one, is showing, starting at the bottom of the key, in the green shading, the strategic growth areas which are part of the SDP, then with a broad grey colouring showing the Aberdeen housing market area, and it's showing that because the strategic guidance is focused, that is, relates to developments that are in strategic growth areas and within the Aberdeen housing market area. And those areas then, on this first plan.
So the Aberdeen housing market area is the whole of the area edged with the wider grey line.
It is.
Whereas the strategic growth areas, most of which are within that line, but not all, are the green-coloured areas.
That's correct. And the strategic growth areas extend, as you can see in, my Lords would like to see, on the in the SDP, extend further out.
Yes, yes.
But the strategic guidance is focused on these areas within.
Yes.
And so looking then at the different coloured dots, residential and business sites, and then separate residential sites or business and industrial sites, and then strategic transport fund interventions, dealt with in the strategic guidance, shown with the red star. And on this plan, grouped in order that the court can see what we're concerned with the black line are the housing and employment allocations within the Aberdeen housing market area and the strategic growth areas in Aberdeenshire. And you'll see that some numbers are given in relation to each of those black-edged areas. Broadly speaking, there are 27,000 houses and just a little short of 240 hectares of business or industrial land identified there.
What does AWPR stand for?
Aberdeen Western Peripheral Route, which is a magnificent piece of engineering, best seen from the air, I may say, at the moment, which, as you can see, avoids traffic going through the centre of Aberdeen to the great discomfort, no doubt, of many people at the moment. And the route is under construction. No more perhaps needs to be said about its purpose at the moment. If you go to the second plan is, as it were, an inset in relation to the first plan, focused just on the Aberdeen city area, which is within the growth area and very obviously perhaps within the housing market area, and there are identified all of the different developments which are proposed in different parts of the city. Broadly speaking, 17,500 houses and about 127 hectares of industrial or business land. All of that information is gleaned in one way or another from the strategic development plan, which I've invited the court to turn to briefly.
Yes.
And turning through it, you will be able to see that there are, for each of the strategic growth areas, numbers given for housing and employment land. The plan simply attempts to summarise what the position is relative to the strategic guidance. And so far as the strategic guidance is concerned, if you want to see the pictorial presentation, MS 151, or page 23 of part 1. Part 1, MS 151, it should be in landscape format, and on the left-hand side have figure 1 under paragraph 4.1 and be headed SGAs in the Aberdeen housing market area. And that is a diagrammatic indication of what we've been looking at, just in a little more detail on the plans that the court has been provided with. And it's we've looked at in that way for the purpose set out in paragraph 4.1, as set out in the strategic development plan. The areas covered by this supplementary guidance are the strategic growth areas, SGAs, within the Aberdeen housing market area. These are shown graphically.
But these talk of strategic growth areas in the plural, and there seem to be 4 in red and 3 in blue, whereas the other plan simply refers to a strategic growth area.
They are differentiated, my lord, in the strategic development plan, and there are indeed, there is
areas.
not just one.
Yeah.
They are identified within the strategic development plan. If you wish, I can take you through each one, but you'll find them.
Just give the references.
Aberdeen, page 50, MS 178. Aberdeen to Peterhead, page 54. I'm afraid it's just 4 pages further on. And then Aberdeen to Huntly, page 56. That's MS 184. And then Aberdeen to Lawrencekirk, page 58. And that would be MS 186. My Lords, it's immediately obvious that the strategic development areas are focused on the city of Aberdeen, and it's not difficult, we think, to imagine that as substantial areas they will interact with each other and have impacts which are cumulative, that is, impacts which arise from the combination of so much development in the area. I turn then to the strategic guidance and the question of cumulative impact. The strategic guidance is concerned only with the cumulative impact of the large-scale development proposed around Aberdeen City and the Shire in the strategic development plan. You can see that if you take up the strategic guidance, page 22, MS 150. And looking paragraph 1.4, although required to allow development of a significant scale to come forward, evidence has shown that even with this scale of investment it will not be enough to address all the transport impacts of the significant scale of new housing and so on. Evidence has highlighted a number of locations where intervention is needed to mitigate the combined cumulative impact of new development. And then the costs. 1.5. The purpose of this guidance is to set out a mechanism to ensure that the cumulative impact of the new development in and around Aberdeen is mitigated in such a way as to facilitate development in the area. It will result in a more proportionate transport assessments. 1.6. It's vital that all cumulative development, and then in section 3, in the right-hand column on the same page, paragraph 3.3, the projects include road and public transport interventions in a variety of locations where the cumulative impact of new housing and other development are likely to cause increased congestion. The guidance makes it clear, and it's at the next page, MS 151, paragraph 4.8, the last sentence. There will still be a requirement to mitigate impacts specific to the development, defined as local impacts, where they are on the local or strategic network. So those are dealt with separately by the application, and strategic guidance focused on the cumulative impacts. We'll just go back to MS 150, page 22 for a moment.
Yes.
And note paragraph 1.1. and what it says about the scale and rate of growth which is anticipated in Aberdeen, something I shall refer to in just a few moments. My Lords, my Lady, the substantial scale of the development proposed is that which is necessary to make provision for the development needs of the strategic development planning area. That's an issue which has been determined already by the strategic development plan, and it's been determined that it is all needed. Without some mechanism to deal with the cumulative impacts of such large-scale developments on the transport network of the area, there is the danger of a race between developers of different sites, trying to take advantage of any existing capacity in the transport network on a, in effect, first-come, first-served basis. The danger with such an approach is that developments coming along later in the plan period than others, but which are part of what is needed to fulfil the strategic development plan requirement, find that there is no capacity available in certain parts of the transport network, extensive and expensive works are required such that they are not affordable by a single development site, so that the development is rendered unviable and can't come forward. Needed development identified in the development plan is thereby frustrated. Scottish planning policy anticipates the sort of exercise that the strategic guidance is engaged in, that is, looking to see what cumulative impacts there might be in the forward planning process. And for this, my lords, my lady, you will need volume 2 of the authorities, or tab 28. MS 1460 is where it starts. 1462 is the part of interest for this point.
Thank you. Yes.
Of course, the situation you're describing isn't unusual. I mean, if one has housing developments, for example, they'll take advantage of existing capacity in schools or sewerage systems, and it may be they can just squeeze into the existing capacity. And the consequence will be if a later housing development comes along, that development may have to bear the cost of additional infrastructure, which might affect its viability.
It might, and as we shall see in just a moment, for that very reason, because the housing and employment man needs of the area have been calculated, and the desire is to bring it all forward. For that very reason, planning policy looks to authorities to do the exercise which these authorities, or this Strategic Development Planning Authority, have done. That is to work out what are you going to need to deliver all of this development, because otherwise, as I've just said, you don't get all of the development for viability reasons. And to put it bluntly, why should some who manage to get into the plan on the basis of a total package get either a free or cheaper ride when their development is no more needed than development that might come along later and find itself with a disproportionate infrastructure burden? So,
and am I right that they did it here by lumping together all the strategic growth areas and making them contribute to all the improvements in all the strategic growth areas?
If I may,
Well, I'm
within
asking,
the,
so, yes.
in the Aberdeen housing market area, they looked at all of the development that was proposed. We're going to come along to the excitements of it a little later on. They undertook a cumulative transport assessment, and then, aided by that evidence, said, if we're going to be able to deliver all of the development that's needed in this area, what are we going to require by way of what were described as transport interventions, works of different kinds,
yes,
to ensure it's all delivered?
Yes.
And then...
Yes, so by cumulative you mean all on one side and all on the other? And
yes, but the reason for concentrating on the cumulative impacts is that, as I've just indicated from paragraph 4.8 of the strategic guidance, the, as it were, individual impacts of the developments, what they needed by way of road junction to get onto the highway network, those are all dealt with as part of the individual development applications. What the strategic guidance was concerned with was trying to ensure that these cumulative impacts, the points on the network where all of these the development traffic from all of these developments was interacting and producing impacts, that was going to be addressed. And as we're about to see, I hope, in the Scottish planning policy, that was something that they were required to do. So MS 1460.
So the assumption in what you just said, as you just said, all the developments are producing impacts. And so this cumulative approach would be addressing infrastructure needs which can be related to all of the developments.
Yes, to a greater or lesser extent. And the argument we have is the extent to which there is that relationship. As we shall see in due course, our submission is that the strategic guidance guarantees that there will be a relationship. But we'll come to that a little later, if I may. So MS 1460, this is Scottish planning policy. It's no surprise, I suppose, that this is under a subheading of delivery, above paragraph 272, dealing with development planning. This is forward planning, in other words. 272, development plans should take account of the relationship between land use and transport, and particularly the capacity of the existing transport network, environmental and operational constraints, and proposed or committed transport projects. I won't read 273 because it's not relevant for my purposes at the moment. 274, that's just the first sentence. In preparing development plans, planning authorities are expected to appraise the impact of the spatial strategy and its reasonable alternatives on the transport network in line with Transport Scotland's DPM-TAG guidance. So, expected to appraise the impact of the spatial strategy. And the spatial strategy is all of the development that's proposed, whether for housing, business, office, and the like. And then going to 275, development plans should identify any required new transport infrastructure on public transport services, including cycle and pedestrian routes, trunk road and rail infrastructure. The deliverability of this infrastructure, by whom it will be delivered, should be key considerations in identifying the preferred and alternative land use strategies. Plans and associated documents such as supplementary guidance and the action programme should indicate how new infrastructure or services are to be delivered and phased, and how and by whom any developer contributions will be made, prepared in consultation and so on. So paragraph 275, explicit, we want you to look at the developments proposed, what impacts it has, what new infrastructure is required, and how it's going to be delivered in order to ensure that the spatial strategy, that is, all of the development proposed, is actually going to be delivered. And that message with regard to impacts and cumulative impacts reinforced at MS 1462 when dealing with development management. Paragraph 286, where a new development or a change of use is likely to generate significant increase in the number of trips, the transport assessment should be carried out. This should identify any potential cumulative impacts which need to be addressed. It is also the case that national policy on the preparation of development plans and dealing specifically with the transport appraisal of them requires that cumulative impacts should be considered. And if you go to 1466, MS 1466, 1465 will tell you that this is Development Planning and Management Transport Appraisal Guidance.
Yep.
And at paragraph 60 and 61 on 1466, this is appraisal of STPs, so the Strategic Development Plan, transport appraisal of the cumulative impact of land uses proposed in the STP is needed to consider how changes in land use for the preferred spatial strategy and alternatives would affect the strategic transport network. Strategic, regional and or local modelling tools are to be used to consider the impact of the development proposed in the spatial strategy. At a strategic level, Transport Scotland's lattice service can be utilised. Some circumstances make it possible to consider the cumulative impacts of development without the use of a transport model. 61. Once the cumulative change in forecast demand to travel is determined, the impact on current and planned transport provision should be assessed. This should cover the lifespan of the proposed development plan, phased accordingly, may need to address cross-boundary impacts. So all of that pointing in a direction of doing exactly here what the Strategic Development Authority has done. The SDP, the Strategic Development Plan here, foresaw that there may be an issue with cumulative impacts and the need for additional infrastructure. If, my Lords, my Lady, you go to page 77 in part 1 of the appendices, MS 205. Section 5, putting this plan into practice. In other words, about the delivery again of what is proposed. Right-hand column, the subheading, providing infrastructure.
Yes.
5.7, to make changes on the scale proposed, we must invest in existing and new infrastructure in the strategic development plan area. Important to maintain quality of life in communities. Existing roads and sewers and schools will not be able to cope with the demands extra development will bring. We also need to invest in facilities, services for communities. These two needs have to be carefully considered very early in the land development process, even before land is identified in local development plans. And 5.8, developers will have to accept the need for contributions towards necessary infrastructure, services, facilities within their own site. However, in cases where the development has wider effects, cumulative effects, we will have to secure contributions to deal with these as well, although the public sector will also need to make an important contribution. So the SDP foreseeing there that there might be these wider impacts, with the aid of a cumulative transport assessment. And
don't we have to look at the next paragraph as well?
We're, my Lord, going to come to the next paragraph, not, I hope, for the minutiae of the language, but for the broad sense of which it speaks. Paragraph 5.9
sounds very defensive.
Yeah, no, not at all. It's a key paragraph, and I'm extraordinarily keen on it for reasons which I shall explain in due course as an important element of our case.
Are we going to read it now?
If you like, of course. The excitement is too much.
You wanted to postpone our gratification.
Well, not at all. No, I won't quote about gratification postponed, but 5.9.
Well, it seems to me that its interpretation is rather important in this case.
Yes, crucial, absolutely crucial. We will prepare supplementary planning guidance in support of this plan. This will allow, through a strategic transport fund, transport projects which are needed as a result of the combined effect of new development to be funded and delivered. The transport projects that will benefit from the fund are set out in Schedule 2. We will look for contributions from business, housing, business, industrial, retail and commercial leisure developments in the strategic growth areas within the Aberdeen housing market area. Detailed criteria will be set out in the supplementary guidance. We will only use contributions to support projects that are related to the development concerned and that are necessary to make those developments acceptable in planning terms. As I've said, I will be returning to it and its terms and purpose in due course, because it appears in the form it appears as a direct result of the recommendations of the reporter who heard the examination into the plan, and as a consequence of a direction from Scottish ministers after that examination. My Lords, the process of deciding what impacts there might be, what cumulative impacts there might be, that is, addressing the policy guidance of paragraph 275, was aided here by a cumulative transport assessment. We don't, at least at this stage, need to look at it in any detail. That, my Lords, my Lady, has it starting at Part 1, page 106, MS 234. And you will see that its heading is Local Development Plans, Cumulative Transport Appraisal of Aberdeen City and Aberdeenshire Local Development Plan. So this was the evidence base in relation to cumulative impacts, the authority taking an informed and evidence-based view of the transport infrastructure that was required to enable it to come forward and enable, therefore, the development in the SDP and the cost of it, the necessary infrastructure to be shared amongst the developers who would benefit, of course, from the development of their sites and the growth in the strategic development planning area. All, as I've said, as paragraph 275 of Scottish planning policy anticipates. The question in this appeal is whether or not that mechanism is lawful. My Lords, my Ladies, some context then on a slightly broader canvas. A number of matters to draw attention to in relation to Aberdeen City in the Shire and the process which we are engaged in. First of all, Aberdeen is Scotland's third largest city. It's a city of global significance, the self-described energy capital of Europe. Its importance is emphasised by its designation as a part of one of 4 strategic development planning areas designated as a consequence of Section 4 of the 1997 Town and Country Planning Act. I don't need to turn to the section. My Lord, my Lady has it already in the bundle. The designation as a strategic development planning area is intended to provide the opportunity for coordinated approaches across local authority areas where significant growth and economic activity is encouraged and is to be facilitated. That process and the importance of SDPs is explained in circular, that is Planning Policy Circular 2 of 2008, for which you need Part 2 of the appendices MS 586 and 7.
I think here we might need the internal numbering.
Very well. Part 2, page 458, MS 586. I've learnt in the process of the numbering to add 128 to all of the numbers at the top of the page in the hard copy. That may or may not be helpful. If my lords have the MS numbers already, then
yeah, we just don't have it in Appendix 2.
Not in Appendix 2.
No, that's very, very...
That's a common problem.
128 is the magic number.
And the paragraph number we're looking at?
Paragraph 4 and paragraph 6. Paragraph 4 deals with designation orders. And I invite the Court just to look over paragraph 4. Vital forum, common approach, travel to work areas, the grouping intended to reflect geographical realities, and then paragraph 6 about strategic development plans, clear vision, spatial strategy, what they're intended to do. As I remarked earlier, and we saw from paragraph 1.1 of the supplementary guidance, that the scale of growth in the Aberdeen Strategic Development Planning Area will make it one of the fastest growing areas in Scotland over the next 20 years, provided, of course, there is adequate infrastructure to support the development that is proposed. Secondly, delivering the substantial scale of growth envisaged in the SDP without the infrastructure needed to support it, to the extent it is possible, is we submit a recipe for disaster. That's why Scottish planning policy, instance paragraph 275, requires the assessment to be undertaken of what is needed. In transport terms, congestion with its significant benefits both economically and environmentally is assured unless steps are taken. But paragraph 41 of Circular 6 of 2013, that's Part 2, page 479, MS 607.
Yep. Thank you.
Paragraph 41, my Lord, my Lady, would just read the first sentence and then the last two starting the principal topics. This is about development planning, and it's simply reinforcing the message that growth and development are linked to infrastructure provision, and SDPs should be planning for strategic infrastructure investment. Thirdly, for the SDP area, it's therefore vital to address the issue of the identification and delivery of infrastructure and the means to pay for it, so as to ensure that all the required growth is delivered in a sustainable way. I've referred earlier to the SDP at paragraphs 5.7 and 5.8. They summarise the position in the adopted and not challenged strategic development plan of what is required. Fourthly, as a part of enabling that process to take place, Parliament has provided a route by which it can be done. That is, the receipt of contributions in order to support the delivery of infrastructure. The route in Scotland is Section 75, agreements or obligations. In England, it's Section 106, agreements under the Town and Country Planning Act 1990. It might be helpful just to see how they are described and have been described, and for this, my Lords need what I'll call Test Code 1995, if I may,
Yes.
Which is at tab 26 of the Authorities Bundle.
Tab 26.
Tab 26
Thank you.
of the Authorities Bundle.
Yep.
For MS users, MS 1417.
Thank you.
And the relevant part for these purposes is in the speech of Lord Hoffman at page 776.
That's internal.
That's
yeah.
MS 1434,
Thank you.
and it goes on to 5.
Yep, thank you.
And on page 776, I beg your pardon, 776 at the bottom of the page, under 8, legislation in support of the new policy. If my Lords, in this paragraph, would go some 4 lines down, you should find a sentence starting, the new section 106. That's the English equivalent of section 75. So we're on page 776, under paragraph 8, 4 lines down.
Yep.
The new section 106 of the Town and Country Planning Act says in express terms that agreements under that section may require a developer to pay sums of money. We'll skip the next bit because it's about English statutes and go to the last 2 lines on this page.
Yep.
Parliament has therefore encouraged local planning authorities to enter into agreements by which developers will pay for infrastructure and other facilities which would otherwise have to be provided at the public expense. These policies reflect a shift in government attitudes to the respective responsibilities of the public and private sectors, while rejecting the politics of using planning control to extract benefits for the community at large. The government has accepted the view that market forces are distorted if commercial developments are not required to bear their own external costs. And external costs are, in effect, the costs of providing necessary infrastructure to deliver the development. So there is Lord Hoffman identifying the route that Parliament has given local planning authorities in order to collect contributions. Fifthly, it is in the nature of cumulative impacts that some of the individual developments may only have relatively small impacts at some locations. That does not, however, mean that they are not significant in the context of needing to deliver all of the development in the strategic development plan. And here we need to look at the guidance on transport assessments and their preparation. It's in Authorities, Volume 2, Tab 30, MS 1480. I should have said it starts at 1467 and it is transport assessment guidance, but the relevant part for these purposes, that is dealing with the size or relevance of contributions, under traffic analysis on page 1480, paragraph 558. Transport assessments must identify both the volume and distribution of vehicle trips related to development and set this within the context of existing traffic movements in the locality. The following should be noted, and I go, if I may, to the second bullet point. The significance of a traffic impact depends not only on the percentage increase of traffic, but the available capacity. A 10% increase on a likely traffic road may not be significant, whereas a 1% increase on a congested motorway will be. Looking at percentage changes is no guide to the need for intervention. Planning judgments clearly are required as to what is significant in any particular situation. Those judgments here have been taken, at least in part, in the cumulative transport assessment we referred to earlier, prepared specifically to deal with this strategic development planning area. Sixthly, but planning officers, the authorities officers, noted in a report of the 10th of December 2014 when dealing with the draft strategic guidance, this is part 2 of the appendices, page 254, MS 382.
Paragraph.
It's paragraph 311.
Thank you.
Two 254, paragraph 311, there is a recognition in Circular 3 of 2012 of the validity of taking the cumulative impact of development into account when assessing the need for developer obligations. Impacts from allocated sites out with the strategic growth areas in the Aberdeen housing market area have been discounted on the basis of the strategy in the strategic development plan. Within this area, however, due to the nature of cumulative impacts, it's not appropriate to set a threshold of significance because they all contribute cumulatively to the problem. If some impacts were to be discounted altogether, this would undermine the principle of mitigating cumulative impacts. And that's clearly again linked to the issue of just because it's small doesn't mean it's significant, and the point taken from the transport appraisal guidance. Seventh,
it all depends what unit you take, doesn't it? I mean, cumulative in relation to what? Ultimately, it depends upon whether you're looking at all the strategic growth areas together, or whether you're looking at them individually, or possibly looking at developments and impacts within them. Are you entitled simply to take the whole of whatever your development plan area is and say, right, over the next few years, there's going to be this amount of development in this area, and everyone who develops anything within our area has got to contribute to it? Is that a permissible attitude? Seems to me one of the issues.
Not without an evidence base, and the evidence base here was the cumulative transport assessment. And if my Lord will forgive me, this was a very focused exercise. Not all of the strategic growth areas, simply the strategic growth areas within the Aberdeen housing market area, focused on the city of Aberdeen and looking therefore at the major development areas that needed to be delivered if the housing and employment land needs were to be met.
Well, that's your choice of unit. Well, you would like to see that block as one unit, and that may be right.
Well, not just our choice, as we shall see in due course, an approach which, as far as the reporter who examined the strategic development plan was concerned, was regarded as a rational choice. But I'm perfectly content to accept that it involves a planning judgment as to the right area. But the reason for concentrating on the Aberdeen housing market area was because outside the Aberdeen housing market area, the development that was proposed, and it's indicated with some rather discrete dots on the plans in the strategic development plan, was growth which was described as local growth. In other words, not growth which is supporting an aim of major development, but simply local growth to support those local areas. And it's the stipple on the plans in the SDP. So a choice has been made, a planning judgment has been made as to the relevant area to be looked at, and within that area, then the guidance in paragraph 275 of the policy has been applied, supported by an evidence base, which has involved clearly planning judgments, but supported by an evidence base, arriving at what are the cumulative impacts, and by the cumulative impacts, that's the impacts on the network which arise from all of the developments that are proposed. If my Lord has the SDP there, almost any of the plans we referred to earlier
have the stippled growth.
Yes, if you look at page 48, MS 176. The stipple is local growth, and the approach which has been taken in the strategic guidance is to focus on, as I said earlier, the strategic growth areas within the Aberdeen housing market area. And it's the Aberdeen housing market area that is the important area from the point of view of delivering the strategy for the area. Outside of the Aberdeen housing market area, although there are still strategic growth areas, they're not related to Aberdeen, not related to its function.
You took us earlier to paragraph 276 of the circular, which said that where public transport services required to serve a new development cannot be provided commercially, a contribution from the developer may be appropriate. The implication of 311 seems to be really that you don't need to make any assessment of whether a specific new development gives rise to a requirement for additional public transport services. You can simply say in advance that any development within a defined area will be taken to have an impact.
Well, that's certainly not the approach which the authority here has taken. The authority here has taken a view that if we're expecting people to make contributions, we need to provide some evidence of the need for those contributions. And the very next point I'm going to come to is relates to one public transport intervention which was regarded as important in the context of needing contributions. But
so 311 ought to be read subject to a proviso that there must in fact be an impact resulting from a particular development before it can be asked to contribute.
yes, and that's what my Lord Mansell asked me to read in advance, as it were, of my original intention, paragraph 5.9, but that's what paragraph 5.9 is saying. That there will need to be some connection, there will need to be some impact before contributions are required. And that's what the Strategic Development Plan provides, as we shall see in due course. It's exactly what the Strategic Guidance provides. My seventh point, by way of context here, relates to something referred to by the respondents in their written case at paragraph 16, MS 113. And it is that there are inevitably relationships in an area such as Aberdeen and Aberdeenshire between the provision of, for example, an additional railway station, in this instance at Kintore, to the northwest of Aberdeen, and developments to the south of the city, such as the respondents' development at Elsick. The railway station provides the opportunity to enable those coming from the development to the northwest to use the railway for their journey and thus lower the impact of development traffic on roads further into the city. That lower impact will mean there's more capacity available on those roads to accommodate traffic using them from other developments, for example, developments to the south. Thus, the railway station in the northwest has a direct and beneficial effect on the ability of the city's roads to accommodate other development, for example, the development of the south. And that precise point was noted.
Is this factually found, or is this your submission?
I'm about to go to where it's factually found, my lord. This point was noted in the Strategic Development Planning Authority's consultation response on the strategic guidance dealing specifically with Kintore Station.
Where do we find that?
Part 2, page 360, MS 489.
Thank you.
So this is the Planning Authority's consultation response, or response to the consultation on the strategic guidance. And on page 360, MS 489, under Circular 3, 2012, the second paragraph,
all but one
of the transport interventions being funded by the Transport Fund are within a 3-mile radius of the city. The exception, Kintore Station, is designed to address a hotspot which does lie within that 3-mile radius. As this demonstrates, the interventions are relatively close together and have strong interrelationships. While consideration was given to contributions which were focused on the strategic growth areas, this did not recognise the cumulative impacts on infrastructure from all development areas to which the Strategic Transport Fund applies. Such an approach would also make it much more difficult to deliver the required infrastructure, and communities would have to wait much longer for improvements to be delivered, something that would go against the focus of the Strategic Development Plan of actually delivering the infrastructure. And if you go to the next page, 361 MS 490, under transport...
I think 489, I think you're departing from plus 128. You're adding 129 now.
Well, if you'll forgive me, the next page. 361 in the numbering.
I think 128 plus 361 does equal.
It does work. I thought it
well, not on... Which
well, anyway.
On my screen it doesn't.
My lords will forgive me. My lord will forgive
the
me.
bit you read out was at 488.
Yes, 488.
Yeah,
so it's 128.
The following page is 489.
Quite. We're now on 490 then.
Okay. Well, let's not worry about mathematics. Concentrate on the law.
I had hoped so.
Anyway, you're reading from page 362? Or
361.
That's what I thought. 489,
489.
Good.
Under transport interventions, I'm not going to read the whole of the paragraph, but the second paragraph, last sentence, Kintore Station's benefits are principally to remove traffic from the A96 and approaches to Aberdeen from the northwest by facilitating access to the city by a much more sustainable mode of transport. Now, the paragraph that I read from page 360 that starts all but one is a paragraph which, if I may say so, is somewhat poorly quoted in the respondent's written case at MS 111, where they miss out in their quotation the most important part of it. So at paragraph 12, MS 111, you'll see the quote. I'm so sorry. The bottom of the page there, under paragraph 12. You see my learned friends quoting.
Yes.
But in the second line, where the ... dots appear,
yes,
it's the very part which would have explained if it had been included. All about Kintore Station and why it was needed. In any event, Kintore Station is included in a list of projects identified to be supported by the Strategic Transport Fund in the adopted Strategic Development Plan, therefore identified as being one of the needed projects plan which was adopted without challenge. And it's included in the list, and we might just go to the list because of the point that's made about it. It's included in the list in the adopted plan.
Which page are we looking at?
It's page 81 and MS 209.
Thank you.
Right, which can you give it again?
Yes,
MS.
page 81, MS 209, in part 1 of the appendices.
Thank you.
Schedule 2 proposals.
Schedule 2 proposals, right-hand column, last bullet point. The transport measures supported through the Strategic Transport Fund to deal with the combined effect of new development on the transport network are, and the first one, a new station at Kintore. No one challenged that as an appropriate part of the statutory development plan. And what's more, it's there, not by some happy circumstance of the authority thinking up, it's there to be supported by the Strategic Transport Fund because the inspector who conducted the examination into the SDP said it needed to be there. You can...
Can we just go back to where we were before on Appendix 2, 361, MS 489? That suggests... Does that support the middle paragraph, your suggestion that the impacts of Kintore Station will be to the south as well as to the north of Aberdeen? It says Kintore Station's benefits are principally to remove traffic from the A96 and approaches to Aberdeen from the northwest. The A96 goes, presumably, does it go up to the northwest?
It goes up towards Inverurie.
Yes. By facilitating access to the city by a much more sustainable mode of transport.
Yes.
So that doesn't directly support what you were submitting, namely that there are benefits to the southeast.
Well, with respect, I think it does, because the effect of the railway station is to allow people to travel by rail and therefore to remove traffic from the network.
From the network in the north.
But it's the relevant part
area
of the network. I mean,
yes.
if it takes people off the A96, how does that help someone approaching Aberdeen from the southwest?
Because there are quite significant interactions between these large development sites, something which the cumulative transport assessment addressed, and addressed at Part 1, page 133, MS 261.
Yep. Where do we look? Yeah.
This, I hope, is section 5.
Yes, it is.
Strategic operational.
Travel movements, yeah.
Yeah, travel movements under strategic operational appraisal. And you'll see it starts by referring to the ASAM4. That's the Aberdeen. This is littered with acronyms, this, isn't it? But Aberdeen Sub-Area Model 4. It's a traffic model, not a person, I may say.
Understand.
Provides forecasts, likely traffic and public transport movements associated with each new development, changes to travel patterns. Provide an example of the distribution of anticipated development-related movements. Appendix C illustrates the level of travel movements between the major proposed developments at White Stripes, which is now called something slightly different, but between White Stripes, Counterswells, and the Lurston developments, and other areas of Aberdeen and Aberdeenshire. 523, the modelling indicates that the movements associated with each of these developments form a relatively dispersed travel pattern, with around 25-30% development-related movements travelling to central Aberdeen, 45-50% to the periphery of Aberdeen, 20-25% to Aberdeenshire. 524 deals with city centre being a major attraction. And then 525, the analysis also suggests that a large proportion of travel movements from these developments to other peripheral areas, which is likely to affect significant growth and employment opportunities provided within the development land around the outskirts of Aberdeen. And if your lordships wish, we can go to Appendix C and see that that is indeed supported.
But Appendix C, which is at page 293, MS, does that show more than simply
well, it shows
increase in travel movements in relation to specific developments moving out from a particular centre?
Well, it shows what the text in Section 5 is telling us. And if I may say so, these, of course, were all planning or transport consultant judgments. But it shows us that there is indeed a relatively dispersed pattern. So to answer my Lord's question, where is an indication that the traffic from developments to the south would go anywhere near the north? If you look at page 167, MS 295, there is a development to the south at Gloucester, and there is its dispersed traffic, including traffic which is going up to the north of the city.
I see. So 4% or 6%. What's the difference between the black and the blue?
I'm really sorry. I would have to pass on that for the moment. I will ask. I think it's less than 5% or more than 5% as an indicator. I think, but no, that can't be right. It must vary according to the diagram. But for present purposes, and to answer my Lord's question, where is the evidence, or where was the evidence which supported the view that development from traffic to the south might go to the north of the city? The evidence is to be found in Section 5 of the Cumulative Transport Appraisal and Appendix C, and it's evidence which needs to be read in the light of what we saw earlier from the Transport Appraisal Guidance, that the use of percentages is not a good guide to the extent of indicating what the impacts might be. Because a small percentage increase on a crowded road might have much greater significance. All of those judgments, of course, taken into account in the preparation of the Cumulative Transport Appraisal, and if I may say so, the CTA supported the Strategic Development Plan. And as we're going to see in a few moments, the inspector who conducted the examinations into the Strategic Development Plan specifically considered whether or not the Cumulative Transport Appraisal was a robust enough document to support the list of interventions included in Schedule 2 of the SDP, and he reached the conclusion that it was. So if I may, I'll just go back to the point I was making about Kintor Station and how it is that it appears in the list in Schedule 2 as part of the adopted plan. I'd said, I think, that it was a consequence of the reporter's recommendation. And if you go to Part 1, page 101, MS 229.
Yep.
These are the reporter's recommendations. They start on the previous page. And you can see that they included at 2, amend the final bullet point of Schedule 2 to read, and indeed as it now reads. Yeah. So Kintor Station is there as part of what the approved development plan has said should be supported by the Strategic Transport Fund. It is not, therefore, now up for debate as to whether or not it should be there, or whether the evidence supports it. It has been determined.
Where is Schedule 2 as amended?
Schedule 2 as amended, my Lord, is at Part 1, page 81, MS 209.
Thanks. Yes.
I beg your pardon, right-hand column, last bullet point.
Yep.
That's what you showed us earlier.
Yeah.
Yes. Now, that is the end of those contextual or background matters, we have then three basic propositions which undergird our case, and I enumerate them as follows. Firstly, the first division was wrong, and I will come to the paragraphs later, but paragraphs 18, 32 and 33 of its opinion was wrong to treat the Scottish Minister's policy in Circular 3, 2012, as a test of lawfulness of the strategic guidance that we are here concerned with. The statutory framework related to the preparation of strategic guidance could have made policy compliance a legal requirement, but as we shall see, it does not. Secondly, the Court was likewise, with respect, wrong to treat the circular advice as the test for lawfulness of any Section 75 agreement that might be entered into. The tests for lawfulness of Section 75 agreements, in England Section 106 agreements, have long been established. See Test Code 1995, and they are not, for very good reasons, as we shall see, coincident with the policy tests. Thirdly, the policy in the Circular 3, 2012 is at best a material consideration to which the Strategic Development Authority should have regard in the preparation of strategic guidance or in considering any requirement for a Section 75 obligation. Departure from the policy might provoke an intervention by Scottish ministers or an appeal by a disgruntled applicant for planning permission. But it is not a test of lawfulness for either the strategic guidance or a Section 75 obligation. And also then, with those three propositions in mind, turn to here the statutory supplementary guidance. Supplementary guidance, statutory supplementary guidance of the kind that's an issue here, is produced in accordance with the requirements of Section 22 of the 1997 Act. In essence, the statutory scheme envisages that the Strategic Development Plan will be the document which establishes the vision for the area and key policies and proposals, the matters of principle. My Lords, my Lady, you have the Act in Authorities Volume 1 at Tab 1, MS 765.
Thank you. And which section do we look at?
Section 7.
So we find that on page 765.
I hope.
Yep. Thank you.
Form and content of strategic development plans. And Section 7.1, a strategic development plan is a plan in which is set out, and I won't read them all because it's unnecessary, but by way of summary, a vision statement, B, a spatial strategy, C, an analysis of the relationship of the vision statement and the spatial strategy, D, any other prescribed matters, E, any other matter which the authority consider appropriate. And the vision statement, you can see from 7.1a, being a broad statement of Strategic Development Planning Authority's views as to how development of the area could and should occur as to the matters, including the matters in subsection 4, which might be expected to affect that development. I pass over to subsections 2 and 3, go to subsection 4. The matters referred to in subsection 1a are, they're listed, I won't read them.
Right.
Section 8 on MS 766, preparation of the Strategic Development Plan. In preparing a Strategic Development Plan or main issues report, Strategic Development Planning Authority are to take into account the National Planning Framework. That's a spatial framework, that's not Scottish planning policies. A spatial framework B, are to have regard to such information and considerations as may be described, that's the regulations, may have regard to other information and considerations as appear to them to be relevant. So this is the document dealing with the principles. To see with the detailed material then, of course, being left for the strategic guidance, to see that summarised in the policy document, if we go to the appendices part 2, page 504, MS 632. This is the relevant policy circular dealing with development planning. Page 504, dealing with supplementary guidance, there's a table at paragraph 139, which is an attempt at a summary, in effect, of the statutory scheme and what should be where. And so, left-hand column, matters that should not be included in the supplementary guidance but be within the plan, that is, within the strategic development plan, departures from policy, proposals of more than local impact, greenbelt boundaries, and the last one, items for which financial or other contributions, including for affordable housing, will be sought, and the circumstances, locations, types of development, where they will be sought. So all of that in the SDP, as indeed it is here in the SDP. And then suitable topics for supplementary guidance, right-hand column, as you'd expect, effectively providing the detail, including the fourth bullet point, exact levels of developers' contribution or methodologies for their calculation. It's right, and my learned friends point out, if we haven't done so, that once lawfully adopted, the strategic guidance becomes a part of the statutory development plan for the purpose of the decision-making process. It's therefore subject to the guidance in interpreting it, that is, in reading it, set out by this court in Tesco and Dundee at paragraph 18. I won't refer to it. I imagine it will be well known at least to some. If need be, we'll come back to it. This challenge is as to the lawfulness of the strategic guidance adopted by the appellants. It is not and could not be a challenge to the strategic development plan, the time for which has passed, and these proceedings should not, we say with respect, admit of a backdoor challenge to the strategic development plan. Likewise, this is not a challenge to the lawfulness of any Section 75 agreement entered into pursuant to the strategic guidance. It's important to bear that in mind because much of what's relied on to challenge the lawfulness of the strategic guidance is policy guidance in Circular 3 of 2012 related to Scottish Ministers' policy on the use of Section 75 obligations. There have been now a number of such agreements entered into related to the strategic guidance. I'm instructed about 25, including, of course, one with these respondents. One was produced in the court below related to the then interested parties' development, and that, I think, has been provided to my lady and my lords this morning, what we'll call for short the Black Dog Section 75 agreement. Yes. Scottish Minister's guidance on Section 75 obligations could not and does not address the issue of the lawfulness of the adopted supplementary guidance. That depends fundamentally on its compliance with the statutory requirements for its preparation. In the light of the way the challenge has proceeded, the relationship between planning policy and the law in relation to the preparation and adoption of the strategic guidance is clearly important. We note, for example, that the First Division took the view that the question in this case, and I take this from paragraph 34 of their opinion, was whether any obligation, as they put it, in the strategic guidance to contribute to the Strategic Transport Fund was lawful having regard to the terms of the circular. My Lords, I say with respect to the First Division that notwithstanding that formulation of the issue, we submit that the lawfulness of the strategic guidance is rooted in the legislative requirements for the preparation of such guidance and not in Scottish Ministers' policy. As we've noted already, the legislative requirements do not include a requirement to abide by Scottish Ministers' policy. They could easily have done so if that was required. The legislative requirements are set out in the section I've referred to already, section 22 of the 1997 Act, and regulation 27 of the 2008 regulations. You might just look at section 22, it's MS 775.
Supplementary guidance, yeah.
Yes. So this is what the Act says. Authority may adopt and issue guidance in connection with a strategic development plan. The authority may adopt and issue guidance in connection with a local development plan, referred to as supplementary guidance. Regulations may make provision as to procedures. 3, subject to the regulations, then there are procedural requirements. Then at 7, Scottish Ministers' right to intervene. And at 8, specifically, Scottish Ministers may by notice require the authority to make such modifications as are specified in the notice, so Scottish Ministers have oversight here. The regulations, MS 789, Regulation 27, in preparing supplementary guidance for the purpose of Section 22, a Strategic Development Plan Authority must have regard to the matters referred to in Regulation 3.2. We don't need to bother with B. 1 deals with what needs to happen on submission, what needs to be provided to Scottish Ministers. 2, Regulation 27, Regulation 2, supplementary guidance adopted and issued under Section 22 in connection with a particular strategic development plan may only deal with the provision of further information or detail in respect to the policies or proposal as set out in the plan, and then only provided that those are matters which are expressly identified in a statement contained in the plan as matters which are to be dealt with in the supplementary guidance. It might just be helpful while we've got the page open to look back to Regulation 3.2, because that was the must have regard to these matters. If the Court be kind enough to look through Regulation 3.2, you will see that there is no reference to planning policy.
That was what page?
That's 788.
788.
Yep.
It starts on 787, goes on to 788.
But you're looking at 3.2. Yep.
I am.
And nothing, you say.
And indeed,
Well, nothing in 3.1
nothing
either.
which supports the view that strategic guidance requires. And it's now adopted, and it's not therefore up for challenge, but you can see from 3.1, Regulation 3.1, that the same applies to the strategic development plan and its preparation. The most significant requirement, clearly, from Regulation 27 is Regulation 27.2, the effect of which is to ensure that nothing gets into supplementary guidance which is not rooted in the policies and proposals of the strategic development plan, and only then when specifically referred to in the strategic development plan as being something for supplementary guidance to deal with. It is thus fundamental to the lawfulness of the strategic guidance to see what the strategic development plan contains. It is the foundation upon which the supplementary guidance sits. In this case, as I've noted already, the strategic development plan is an adopted part of the statutory development plan. It was adopted in March 2014. It's important for the reason I've said to see what's been approved, because it impacts on the ability to challenge what's in the strategic supplementary guidance. As we've said, we note there is no requirement to abide by Scottish Ministers' planning policy. So, my Lords, with that highlighting of the foundation that there is to be in the SDP, we turn to it, and we make the following points by way of summary of our position. The draft SDP contained a reference to a strategic transport fund. The draft is in Part 2, page 236, MS 364.
Yeah.
And you will see from page 236, MS 364, that the paragraph 5.9 in the draft is rather shorter than the paragraph that I earlier read from the adopted document.
Can you give us a page number of that, just for reference?
Yes, of course. The adopted version is page 77 in Part 1, MS 205.
Thank you very much.
These respondents had fundamental objections to that reference in paragraph 5.9 to the Strategic Transport Fund. They relied in their objections, and objections are summarised by the reporter we'll come to in a moment. They relied on the terms of Circular 3, 2012. Their objections included those related to the proper application of the policy in the circular, and they were in due course considered by the reporter. The objections are conveniently summarised by the reporter with his conclusions on them in Part 1, page 94, MS 222. See at the bottom of page 94, MS 222, reporter's conclusions, and he summarises the concerns of paragraph 2 there, on to page 95, MS 223. And you will see that he deals with the level of detail. And then, will you please particularly note the second bullet point, it's the first on page 95.223, the principle of the fund, and in particular the pooling of contributions. So there is an issue that was being debated in the context of the SDP, the principle of the fund and the pooling of contributions. He went on also to address development viability, schemes to be supported, which schemes were to be supported, and whether there should be a reference to the supplementary guidance. So each of those matters being debated in the context of the SDP. Secondly, in the light of those objections, the reporter had to particularly consider whether or not the cumulative transport appraisal, the document we looked at earlier, prepared specifically to consider the cumulative impacts, was adequate to support the claim that there were cumulative impacts which were required to be addressed as a consequence of the level of growth identified in the SDP. It is some indication of the detail and care that was taken with those matters that in consideration of them, the reporter issued what was regulation under the development planning regulations, Regulation 22 request for additional information. Those the documents consisting of his request and the authority's response are in the supplementary appendices MS 1487 and 1491. I don't need at this stage to turn to them in detail. I draw attention to them with just the purpose I've indicated in mind. This reporter was keenly interested to know, had he got evidence which was capable of supporting what the authority said was the position, and so the supplementary information produced. The third point, that information and others was then referred to when he reported on these matters. If you go to page 95, part 1, MS 223, paragraph 6 starts there, considering the use to which contributions should be put. Go over the page, you'll see second line, however, in response to a further information request. And he also referred to the further information he'd received, MS 225, page 97, in the continuation of paragraph 11. In paragraph 11...
What date is this?
The report was the... Give me a moment. I wrote it on the wrong part of the document, I'm afraid. Mr. Sutherland will tell us in just a few moments.
Well, it must be, quite late. I mean, are we talking
it's
about
part
2015?
Of the SDP. Well, the SDP was adopted in 2014. So it will have been before that. Prior to 2014. Yes. Forgive me, I will get...
But it's after the July 2010 cumulative transport appraisal.
Certainly, because the cumulative transport appraisal was specifically referred to in his request for further information under Regulation 22.
So does it follow that he can't have thought that those graphs showing traffic emanating from all points of the compass in greater or lesser percentages were conclusive on this particular point of interrelationship of improvements and developments?
No, not at all, because what he asked for was reassurance that they were robust at the level of detail that the strategic development plan was dealing with. And he received that assurance and incorporated it for the reasons identified in paragraph 11 of his report, as we're about to see. So, paragraph 11, he refers to paragraph 17 of 3 of 2012, requires there to be a clear link between the development and any mitigation. In this case, the cumulative transport appraisal, so there we are at the top of that page, demonstrates, and he there sets out, firstly, that the overall growth in traffic brought about by the level of development probated in the plan will, without mitigation, have harmful effects on the operation of the network in terms of increased journey times and congestion. Secondly, the cumulative transport appraisal shows that a defined package of interventions will assist in mitigating those impacts in various key locations. Then he deals with the interventions that have been identified, refers to his further information and says that the CTA is suitably robust for this tier of plan making. The cumulative transport appraisal has been carried out by recognised professional consultants in association with Transport Scotland, as well as the local authorities. I've seen no convincing evidence that leads me to question its applicability to strategic development planning. So the information sufficient, and necessarily his conclusion that the schemes identified, that have been identified in the cumulative transport assessment, and which were proposed for inclusion in the Strategic Transport Fund, to be referred to at paragraph 5.9 of the Strategic Development Plan and Schedule 2, satisfied that those were properly to be included as being schemes which were needed in order to address impacts which would otherwise arise.
Where do we see that?
Paragraph 11, my lord. Well, paragraph 7 and 11. Perhaps I should say 7 as well. where he deals with the descriptions of schemes listed in Schedule 2 are sufficiently specific, and concludes at the end of paragraph 7, on balance, I conclude the plan contains a sufficiently precise description of the schemes that are to be supported. So all of that then addressed by the reporter. The reporter noted, and this is paragraph 12, the Scottish planning policy references, and he picked up paragraph 20 of Circular 3 of 2012, to authorities taking cumulative impact into account. See the specific reference there, but was not satisfied with the mechanism that was then proposed to link the contributions to be made to the Strategic Transport Fund and the schemes identified in the Cumulative Transport Assessment and Schedule 2 of the Strategic Development Plan. And if you go to paragraph 14, you can see him most clearly expressing that thought there. Perhaps the last third of paragraph 14, I conclude that the mechanism currently envisaged by the authority in the Strategic Transport Fund would not comply with national policy as expressed in Circular 3 2012 because the relationship between the development supplying the contribution and the infrastructure improvement to be delivered is not sufficiently clear or direct. So he was quite clear something needed to be done. If you go over the page then to paragraph 16, MS 226, just the second half of paragraph 16, I consider that the issue of whether contributions from across the region may be pooled into a single fund and potentially spent on infrastructure related to the contributing development is sufficiently important policy principle to need to be established in the plan itself. This is particularly the case given my conclusion of paragraph 14. Such an approach would be a departure from policy. So, no doubt at all that this is all an issue, all being considered by him, question of pooling, a strategic fund, contributions and how they're to be used. And then, in order to address the issue, that is the issue of linkage between contributions and developments, the reporter considered, and paragraph 17 and following, the wording of paragraph 5.9 as it had previously stood. And he then went on to make a recommendation, which you can see set out at page 100. This one's easy, 228, MS 228. With regard to the wording of paragraph 5.9. So his solution, having been satisfied that there would be impacts, that the impacts needed to be relieved, and that the schemes identified in Schedule 2 would relieve them, his solution to the question of providing for an adequate linkage was the suggested wording that we see there, the amendment to paragraph 5.9. In particular, my lords will note, he did not suggest that it was necessary to produce any new table or new calculations. He simply suggested a wording of the kind referred to in paragraph 5.9. Whilst it's clear that the First Division noted that the reporter had identified a problem, it does not, with respect, seem then to have considered the relevance of the solution that the reporter identified to the problem. And you can see that the First Division identifying the problem in paragraph 35 of their opinion, MS 146.
Thank you.
Can I just ask one or two questions? You didn't take us to paragraph 13, but that's where one finds the factual basis, I think, of his concerns. Is that right?
Yes.
And I'm just thinking about where the argument's going. If you have a legal rule that on a proper construction of the planning acts, conditions and agreements can't be used in effect to extract a development land tax from developers. If that's a statutory rule, if the effect of the strategic development plan was effectively to approve what one might categorise as improper levying of charges, the consequence would be what? The plan would be ultra vires, but you would say it's not challenged in these proceedings.
It was not challenged, and the reason it was not challenged was because it avoided what my Lord has indicated would be an improper legal outcome. It avoided it by the change of wording to paragraph 5.9, which provided, in essence, that there should be some linkage.
Right. So you're not arguing effectively, even if the plan might be regarded as having done something which legally it ought not to have done, that's past praying for, at least as far as these proceedings are concerned.
I don't need to, because the plan has not done what it should not have done. But as a matter of fact, it was not challenged. So, in effect, both apply. But the important issues of principle, the pooling of contributions to support a specific fund with an identified list of interventions, all of those matters are not now acceptable to reconsideration as to whether or not there was the evidence, was it the right thing to do, was it a proper approach. They have been dealt with.
Have they? I mean, paragraph 17 seems to me to suggest that he thought that further attention might be needed as to the appropriateness of an overall fund, because he suggested that the phrase was acceptable, fourth line, on the basis the authority can, within the scope set by the plan, further define the characteristics of the fund, including, for instance, whether it may be subdivided into a number of separate accounts. So he's suggesting that it might be inappropriate to take the whole as the relevant unit, and the truth is that in order to get the appropriate relationship between improvements and developments, you might have to have a more subdivided, differentiated approach.
But his recommendation, as it ultimately comes at the end of this section of his report, was what we find in the now enlarged paragraph 5.9.
Yes, the enlarged paragraph 5.9 may be saying nothing more than the same thing in different words, namely that in one way or another you've got to ensure some relationship between individual developments and improvements, which is the problem which he's identified about the original scheme. So he may not actually be answering anything. He may just be saying, as long as you, in one way or other, do what I say is necessary, you'll have to find a way of doing it.
Well, and that's what paragraph 5.9 was intended to do, with its now in its adopted form in the SDP final sentence.
But I thought you were relying on this as approval of the idea of overall pooling of everything on both sides, and I'm not sure he is accepting that.
Well, he most certainly didn't reject it, if I may say so. And he
doesn't he throw it up and say this is a big problem? And
no, with respect, he doesn't. He reaches a conclusion at the end of this section of his report. He reaches a conclusion, which is a conclusion where he satisfies himself as to ensuring that there will be some connection by way of the wording which is recommended for paragraph 5.9, and that, the last sentence, we will only use contributions to support projects that are related to the development concerned and that are necessary to make those developments acceptable in planning terms.
Yeah.
So there was the report, and as I said, the First Division appears to have focused on the reporter's identification of the problem in paragraph 35 of its opinion, and not on the solution that he identified. That is the solution in paragraph 5.9 and in particular the last sentence. The next point, paragraph 5.9 of the adopted strategic development plan accordingly follows the substance of the recommendation of the reporter, a recommendation that was accepted by Scottish ministers to provide the link between the contribution to infrastructure and the development proposed. And, in part 2, page 2412, MS 369, this is the Scottish ministers' modifications arising from the consideration of the examination report. The letter which accompanied it is on the previous 2 pages.
Yeah.
And you'll see it.
Which paragraph?
241,
Yep.
9.
Thank you.
Bottom
Sorry,
of the page.
which MS page again?
241 on Appendix 2.
369.
369.
369.
Very beginning of Appendix 2.
369
Yeah.
is the MS page. Bottom of the page. Amend paragraph 5.9 to read. And the reasons given accepting the reasoning of the inspector. And we can anticipate, of course, that Scottish ministers would have had their own policy in the circular well in mind in considering what the reporter said. So, my Lords, paragraph 5.9 of the adopted SDP, then, as recommended by the reporter, adopted by Scottish ministers, accordingly we submit that the SDP, as adopted, establishes the following as a foundation for the strategic guidance. Firstly, in accordance with national policy requirements, it identifies that there are cumulative impacts from development proposed in the SDP that needed to be addressed. Secondly, it has identified in its Schedule 2 a suite of measures specifically considered and recommended by the inspector required to mitigate that impact. Thirdly, it identifies the Strategic Transport Fund as being there to address cumulative impacts arising from developments proposed in the SDP area. Fourthly, it identifies the projects that will benefit from the STF, sets them out in Schedule 2. Fifthly, it says what types of development will be expected to contribute to the STF. Sixthly, it confirms that contributions collected via Section 75 obligations will be used to support projects related to the development concerned and which are necessary to make the development acceptable in planning terms. In other words, it provides the link. The SDP having been adopted, as we've said, it was not subject to challenge, whether related to the approach to the application of circular advice, the principle of pooling contributions, or any element of paragraph 5.9, or any element of Schedule 2 and the list of transport projects to which the STF was to be related. It follows, we submit, that the planning judgments of the reporter and Scottish ministers as to the adequacy of the information provided, the links between the impact of the development proposed in the SDP on the transport network and the projects referred to in Schedule 2 was not subject to any challenge. Those issues of principle have been established by the SDP process. In particular, what the reporter identified as the missing link in the SDP has been provided by the paragraph 5.9 amendment something to be put into practice, of course, in considering any Section 75 obligation at a later stage. That, we submit, is important because any issues about the connection between the cumulative transport impacts of the development identified in the SDP and the projects to be supported by the Strategic Transport Fund have been addressed in the process leading to the adoption of the SDP, including, for example, issues related to the certainty of the identification of the projects listed in Schedule 2, the extent to which those were properly linked to identified cumulative impacts, and the mechanisms by which contributions would be sought in the area covered. Those were, of course, matters which involve quintessentially planning judgments, and they've been addressed in the correct forum.
Am I right in thinking you accept that paragraph 5.9 still requires there to be a relationship between between a particular development and the infrastructure to be funded through the Strategic Transport Fund?
It requires there to be some connection.
And whether there is a connection in fact between a particular development and the requirement for infrastructure isn't itself determined by the SDP.
No, it would be determined on a case-by-case, application-by-application basis.
Yeah.
That is, it would be determined in the context of a particular Section 75 agreement, not as a matter of principle related to the lawfulness of the supplementary guidance. So, my Lords, having dealt with what the statute requires as a foundation for the supplementary guidance, I turn to it. Following the adoption of the Strategic Development Plan in March 2014, the appellants moved to convert what had previously been non-statutory supplementary guidance to statutory supplementary guidance. The adoption process is dealt with in the statement of facts and issues in the written cases. We don't propose to rehearse it. We do, however, draw attention to the fact that the respondents do not challenge the lawfulness of the supplementary guidance on the basis of any failure to comply with either the requirements of Section 22 of the 1997 Act or any failure to comply with Regulation 27 of the 2008 regulations. It thus follows that they do not suggest that it departs from the remit provided for it by the SDP in paragraph 5.9 in Schedule 2, or that it offends any aspect of the statutory framework. Accordingly, we submit any consideration of the lawfulness of the supplementary guidance proceeds on the basis that it complies with what the statute requires for the preparation of such guidance. As we've noted earlier, those requirements include a requirement to follow either generally. Those requirements do not include a requirement to either follow generally or at all Scottish Minister's policy. The statement of facts and issues and written cases note that in accordance with Section 22, the finalised proposed supplementary guidance was submitted to Scottish ministers as required. Ministers identified only one modification that they thought was necessary in their letter of the 2nd of June 2015. You might just look at that. It's in Part 1. Page 105, MS 233.
Thank you. Yes?
And it's a letter, as I've said, 2nd of June 2015, written to the authorities. Refer to the correspondence certifying notice of your authority's intention to adopt STF supplementary guidance in association with the Strategic Development Plan. Scottish ministers give notice that the Strategic Transport Fund supplementary guidance may not be adopted until the following modification is made, and then one modification. After the second sentence of paragraph 6.1, insert a new sentence. The use of any planning obligation shall follow the guidance in Circular 3, 2012, planning obligations and good neighbour agreements. It necessarily follows that ministers did not think that anything further was required in order to comply with what they had in their policy. The insertion of that sentence does not, we submit, contrary to the views perhaps rather tentatively advanced by the respondents, make the policy a legal requirement. The supplementary guidance is a part of the development plan, but development plans are not statutes. They may be lawfully departed from. They're not analogous to statutes or contracts. For that proposition, if it needs support, I rely on my Lord in Tesco and Dundee in paragraph 19. That required modification is, of course, consistent with the reporter's required modification to paragraph 5.9 of the SDP, and it's forward-looking in the sense that the strategic guidance anticipates that there will be Section 75 agreements to address the payment of contributions. You may already have seen it, forgive me if you have, but we could note it in the supplementary guidance at paragraph 6.1, page 25, MS 153.
Yes.
And you can see that's exactly what's anticipated at the beginning of paragraph 6.1. Of course, for those who do not wish...
Can you just understand how you say this is going to work, then, the strategic supplementary guidance? When you have an agreement, a statutory agreement providing for an obligation, are you saying that there will be no question of applying some preconceived notion of what relevance to a particular improvement the particular development has? It'll all be worked out from first principles in a way which ensures that a development, for example, in the southeast won't have to contribute to Kintyre Station in the northwest unless it can be shown that the development would in some way increase traffic sufficiently materially to have some effect on the need for a new station in the northwest?
The way, I hope I'm correctly understanding my Lord's question, forgive me if I'm
well,
not.
It was a rather complicated one, yes.
No matter. Let me see if I've
I'll
understood it
rephrase
correctly.
it if you like.
Let me see if I've understood it correctly. The way in which it will work is that contributions will be collected on the basis identified in the Strategic Development Plan and in the supplementary guidance. Those contributions will be held for a 20-year period and will be used in accordance with the terms of the supplementary guidance and the SDP. In the course of that process, and I'm going to come to it in detail in a moment, this is entirely transparent. There is an annual report, what's happened to the money, where it's gone. In the course of that process, if money is not used, money contributed by a particular developer is not used in order to support an intervention which is related to some extent...
How can that be told? It's all the money is going into a pot, isn't it?
Well, it is going into a pot, but the pot is precisely why the issue of pooled contributions was being resolved at the SDP stage. But at the end of the process, if the strategic authority can't identify that money which has been contributed has been used to support an intervention which is related to the development that contributed the money, they must pay it back.
But it's bound to have been used one would have thought, for a purpose which it'll be possible, if everything's pooled, to say you put in £10,000 or £1,000 and we have done an improvement near you and we relate the two.
Well, it would have to be demonstrated. That would not be sufficient. It would have to be demonstrated that there was some relationship.
But this postulates that the working out, after the event, you're not doing it before the event, but after the event they've got to be able to demonstrate that in fact those near Kintyre Station whose developments do affect the need for the station are the people who paid for Kintyre Station.
Kintore.
Kintore.
Apologies. Mullov, but not in this instance, never in Kintore. Right. No. It's, but that is the importance of the foundation that the SDP establishes in paragraph 5.9 of Schedule 2. It establishes that there will be a strategic transport fund. It establishes, paragraph 4.9, that developments of the kind referred to in paragraph 5.9 will make contributions to that fund. It also establishes, last sentence, that in the use of those contributions, the strategic authority will be required to demonstrate that they've been used in a way which relates them, provides the link to the development which has provided the money. And if they
in the sense that there is a cumulative impact. So the link is simply into the overall strategy to provide the total of infrastructure improvements.
Required.
Yes. So if a development in the south contributed to something that was happening in the northeast, let us say, that just happens to be where the funds were used, that would still be perfectly acceptable because it was justified by the cumulative impact.
So what you're saying is that is authorised by these documents.
Yes. And that was the whole point of the
I thought you were saying something different.
No,
the documents provided for a differentiated scheme, and that therefore there was no challenge to documents, and it was all dependent on the facts.
That's why the examination and the strategic development plan examination, which is the strategic foundation for the fund, was so important. Why the evidence base was examined with such care by the reporter.
Can I be sure I've understood? In this supplementary guidance, we see, for example, in paragraph 4.3, that all housing developments within the specified areas will be expected to make a contribution. The contributions are, one sees in section 5 of the document, are fixed. There's a level depending on essentially the amount of the size of the development. So you contribute to the strategic fund, which is available to be used for a whole bundle of infrastructure projects, without there being needed to be established a specific link between your development, your housing development, and the and any particular project being funded at a contribution stage. And you're not saying, as I understand it, that at the stage when the money is spent, it can only be spent on a project which is linked to the impact of a particular development.
My Lord, I am saying
you are saying that. So if, for example, Mr. Martin's clients contributed, just say for the sake of argument, £100,000, are you saying that £100,000 has to be earmarked, is in fact earmarked for projects directly connected to the impact of Mr. Martin's client's project?
It will have to be demonstrated, if I may, going to paragraph 7.3 of the supplementary guidance. No contributions from development sites will be used to support projects where the development in question is predicted to gain no mitigation benefit from the infrastructure provided, and therefore is unrelated to the development making the contribution.
Is this an assertion or is this an undertaking?
No, it's an undertaking, and for those who want it, it will feature in any Section 75 obligation. So
yes, but you read the next sentence. The CTA has shown that delivery of each of the projects identified above is necessary to make all developments acceptable in planning terms. And if you turn back from 7.3 to 5.4, you see that what's being looked at is the cumulative impact of all the various developments rather than any particular development, because what you're saying is you don't have to pay into the STF. You can make your own your own comprehensive transport assessment, but it has to be one which looks at the cumulative impact and the question whether, in fact, that's feasible at all.
So, if I may take my Lord's point, in effect, paragraph 5.4 is the opt-out provision.
Yes.
If a developer takes the view, you're never, if I can put it colloquially, you're never going to be able to pin on my development any cumulative impact contribution. I'm not going to contribute to the Strategic Transport Fund. I wish to go my own way on this. Paragraph 5.4 entitles him to do so. Yes. It's in the guidance. So he then says, right, I know that you've done all this cumulative transport assessment, but I am not going to contribute. Here is my appraisal of the impacts of my development, including the cumulative impacts. It demonstrates whatever it does, and my contribution is.
And the developer could then argue cumulative impacts in the context of my development means something closely related to my development and associated developments in my area and the immediately located improvements in my area, I suppose, and might get a different result. But can that possibility justify the validity of this scheme if otherwise it is not valid?
It does not. The fact that there's an opt-out doesn't make the supplementary guidance therefore lawful. And I don't make that submission. But I do make the submission that for those who say, how will you ever show that there is a link between my development and any cumulative impact? It does provide, as part of its statutory scheme, the opportunity to opt out and do it a different way. So anyone who has any doubts about whether or not they should be making the contribution which they would make if they followed the supplementary guidance route has the opportunity of going by a different means. That means that from the court's point of view, if I may say so, that the focus is on paragraphs 6.1 and 7.3, both conveniently on the same page. Last sentence of 6.1, last sentence, the use of any obligation shall follow the guidance in. Here's the authority committing itself to it. 7.3, no contribution shall be used other than in accordance with the guidance. And if your lordships would like to see a practical way in which somebody thought that they might ensure that the authority was kept to its word, if you take up the supplementary documents that were provided with this morning, which was before the court below, which I'll call for shorthand the Black Dog Section 75 obligation of the 14th of September 2014. It was a separate document. My Lord's had it this morning.
I think we had it on our desk this morning. Is it this document?
That's it. And it's, as I said, for shorthand, the Black Dog Section 75.
Yes.
Go to Clause 7, page 11, Clause 7.
Yes.
The party, 7.1, the parties here to agree that as the date of signing this agreement, the STF contribution is payable in terms of the SPG, and the proprietor shall pay the STF contribution to the Council in accordance with the terms of Clause 9 below, and the Council will be obliged to utilise the STF contribution on the cumulative infrastructure requirements in accordance with the SPG. So, in other words, you will not spend our money on something which does not relate to our project. That's what the SPG says at 7.3
Well,
and 6.1.
I think that's playing with words with respect. It's saying you will not spend money on something which isn't a Schedule 2 project, i.e. the things that are designed to achieve the mitigation of the cumulative impact.
No, it's somewhat more, my Lord, if I may, because to be in accordance with the SPG would be being in accordance with paragraph 6.1 and also 7.3.
Are there any accounts produced to show what I imagine would be a pretty complicated analysis of how individual contributions have been spent in relation to individual developments. If it's possible at all when you've got a pooled fund.
Well, it's possible to the extent that as a matter of principle, as I've said, the pooled contributions element has been dealt with.
I mean, it requires unscrambling the whole scheme, doesn't it? It requires saying you go back to base and you don't look at the thing as cumulatively at all. You relate each development as one of the schedules did originally and to each improvement.
No, I don't think with respect it does, because the foundation that was laid and lawfully laid in the SDP is a foundation which is addressing cumulative impacts arising from developments in a particular area and related to a particular range of interventions designed to relieve the problem of cumulative impact. And to answer my Lord's question of how is this to be handled in terms of reporting, if you go to Part 1, page 34, MS 162, yes, it's just the convenient beginning of Appendix 5 of the supplementary guidance.
Thank you.
The part that matters for the purpose of my Lord Mance's question is at the next page, page 35, or MS 163, which is annual review and reporting, which sets out an annual report will be produced, a 5-year review, the outcomes will be incorporated. So the process, my Lord, is entirely transparent. And those who have entered into Section 75 obligations will be entitled, as a matter of law, to hold the authority to account for the way in which their money has been used in relation to any of the Schedule 2 interventions. So it is not the case that the authority is, as it were, once the Section 75 agreement is concluded, the authority is off the leash and able to do what it likes with the money. No, it isn't. It's required to account for it in the way indicated.
Can I just ask a bit more about that? You took us to 7.3 in the supplementary guidance on MS 153 and the first sentence, and Lord Hodge drew attention to the second sentence, which takes us to Appendix 2. If one goes to Appendix 2, at the top of 157, we're told that Table 3 below demonstrates the linkages between the development zones and the cumulative infrastructure requirements. There is a linkage between all zones and all interventions, and they are cumulatively significant. While the table does not assess the strength of the relationship between zones and interventions, it does show that the relationship exists. Now, when you look at the table, you can see, for example, if you look at the development zone home farm, and
I'm so sorry. Which development?
Table 3.
Yes.
I was just taking it as an example, just to see how far this goes. Home farm, which is the fifth from the
yes.
bottom. And if you go 2 along,
yes.
I think what's being said there is that the proportion of new development traffic from home farm using the A947 will be 1/10,000th.
Yes.
Yep. And that's the link.
Well, it's a link, but what the court doesn't know, and if I may say so, ought, with respect, not to be concerned with, is whether that's significant in the context of the traffic on the A947. Because those were the very matters, whether these Schedule 2 projects listed, were they appropriate for inclusion? I mean, those are the very matters which would be considered at a later stage when a developer was saying, well, what have you used my money for? Provide me, in accordance with the supplementary guidance, an account of its usage in relation to where I have gained benefits. And if there is no benefit and his money has not been spent, he gets it back. It's quite simple. And if he, as I said, if he chooses not to contribute it in the first place and to go his own way, he has the opportunity of doing it. But this mechanism is designed to provide the opportunity for those who recognise that there will be cumulative impacts, a straightforward, if I may say so, compared with some, straightforward methodology which allows them to make a contribution, get on with their development, and leave the Transport Authority to sort out the provision of infrastructure to support it.
How are you going to know whether one car in 10,000 from your development uses a particular road as opposed to 0 cars in 10,000? Is every developer or are your clients actually going to be surveying every car using every development? Well, the logic of your proposition is that if things haven't worked out quite as expected when you're levying the charges, then they're all adjusted later on an actual basis.
No, not adjusted in any way, because as we're going to see in a few moments, the lawfulness of this guidance does not depend on the contribution being fairly and reasonably related to the development. That's a policy requirement. All the law requires, as we'll see in a few moments, is that there should be some connection which is not de minimis.
Yes, but again, I'm puzzled from this discussion as to what paragraph 7.3 achieves. You say that you found on the first sentence that no contributions will be used to support projects where the development in question is predicted to gain no mitigation benefit. But the next sentence says the CTA has already shown the cumulative impact, means that all these developments have got a mitigation benefit. So the authority is not envisaging some discussion with the developer after the event, either in the negotiation over Section 75 or after the money has been paid, where the developer says, well, actually, I haven't got a mitigation benefit.
With respect, the second sentence is not concluding on the first. Otherwise, the first would be unnecessary and would have been unnecessary. The first is a quite separate proposition and obligation to the second. The second is saying, if I may, the second is saying as a matter of fact that the CTA has shown that the delivery of each of the projects identified above is necessary to make all the developments acceptable in planning terms. That is taken as a whole accepted. Yes. That's exactly the question that the reporter considered in the context of the strategic development plan. He said, have you produced evidence to show that these interventions taken as a whole are required to address the cumulative impacts of these developments taken as a whole in order to ensure that the development plan gets delivered?
And that's how you read the first sentence, doesn't it? I mean, the first sentence, I think you're reading it as a sort of promise. One could read it as an assertion for which the evidence is the second sentence.
Precisely.
No, I think not, because otherwise 7.3 would be inconsistent with 6.1, which is an obligation to follow the guidance in Circular 3 of 2012, a matter which would be considered at the point at which any Section 75 agreement was either being entered into or being considered as to whether or not a developer wished to take action. The document, forgive me, needs to be read as a whole and to, so far as possible, ensure that the reading doesn't make it internally inconsistent. And it's noteworthy, I submit, noteworthy that Scottish ministers, when they made a modification to the strategic guidance, did not say, not only do we want this sentence put in paragraph 6.1, we want some modification to 7.3 because we don't think it's consistent with our policy in 3 of 2012. So, if I may, quite to the contrary, I think my reading of paragraph 7.3 makes the document internally consistent and makes it consistent with the approach adopted by Scottish ministers. And if my my reading were wrong, then one would expect that Scottish ministers would have taken steps to have either modified the guidance, removed paragraph 7.3, or changed it. But that was not regarded as being necessary. And neither, it's to be noted, my Lord has referred to the table in Appendix 3, but it is a table in an appendix. And I've noted already that the reporter, when he was reporting in the context of the SDP, and the table 7.2 was there to be, it was then table 7.2, not table 3, was there to be considered. The reporter didn't say, just a moment, I'm not going to let you proceed with a reference to the Strategic Transport Fund without a new table that produces, at this stage, and these are interventions which have not been worked up in detail, I want you to produce a new table at this stage which sets out precisely how much use of each of these interventions, each of these development zones will make. And he didn't do that for the very sound reason that from his point of view, the amendment that was made to paragraph 5.9 would ensure that as interventions were worked up and the detail of them, because there were no detailed schemes then in place, the detail of them worked up and the extent to which particular developments might use them, those are matters which were going to be considered further down the road in the context of particular Section 75 agreements. So no requirement to amend the table then, and no requirement subsequently from Scottish ministers to change the table or produce a new table or strike it out. So the table is not to be relied on, I submit, as, well, this is it forever. This is an indication of impact or not, because it's certainly not intended to be used like that.
Well, paragraph 7.3 directs us to Appendix 2, and we're told in Appendix 2 that Table 3 demonstrates the linkages.
It does, but with respect, all that Appendix 2 does is to take up the reporter's conclusions, and the reporter's conclusions, you will recollect from paragraph 11 of his report, were addressing the fact of impact, the fact of a need for intervention to relieve the impact, the fact that the list of interventions identified was appropriate to relieve the impact, and then he said, how do I make sure that I link the particular developments to the interventions that are identified? I will modify paragraph 5.9 so that the strategic development plan provides the link in the wording used. A link which is then followed through in paragraph 7.3 and also in paragraph 6.1 with the reference to policy. Followed through in the strategic guidance, but which is something which would be worked out in the context of a particular Section 75 agreement and a particular development. And it's not something, I say with respect, which could be resolved now. And all that Appendix 3 does here is to summarise, so for example, some of the tables in Appendix 3 are tables which are taken straight out of the cumulative transport appraisal, an appraisal which has been subject to examination and in that respect regarded as being appropriate to support the now lawfully adopted SDP. So, my Lords, to go back, if I may, to where I was, we've seen that there is the opt-out clause. We've seen that there is the commitment to use monies in a way which will ensure that there is the link that concerns the reporter. And we see that, at least in the Black Dog Section 75 agreement, the authority are committed to abiding by demonstrating that that linkage is there. Notwithstanding that, the respondents assert the strategic guidance is unlawful, but that's an assertion which must contend with the fact of an absence of challenge to the SDP and the acceptance of the lawfulness of the approach in paragraph 5.9. Let's contend with the fact that the SDP establishes after examination the efficacy of the cumulative transport appraisal, its assessment of cumulative impacts and the need for mitigation. And thirdly, contrary to the respondent's view, it uses a carefully drafted contribution scale in order to ensure that contributions are related to the scales of development and their likely impact on the transport network. And for that, we need Part 1, page 33, MS 161.
Can I ask, just for information, the reporter's concerns in paragraph 13 of his of the document he took us through at MS 225, his concerns about the lack of linkage related to table 7.2 of the cumulative transport appraisal.
Yes.
I'm wondering if that's effectively the document that we're looking at as on page 15, MS 158.
No, it's not, because after the reporter's criticisms or comments on table 7.2, the authority did some further work. If you take up part...
This is the revised 7.2, isn't it? Table 3?
Yes, it is.
They're the same.
Oh.
And so presumably come...
No, I'm sorry, they're not the same.
Aren't they pretty simple? No. Let's have a look at them then. They look the same to me. Their proportion of new development traffic using specified new road infrastructure or using road infrastructure. The percentages seem to be the same.
Could I ask you to take up part 2, page 244, MS 372. 244, MS 372.
Yes.
In part 2.
Okay. Yep.
And the bottom of page 244.
Yep.
With the approval of the SDP, there is, and it should be now, I think not, now the opportunity to turn the non-statutory guidance into statutory supplementary guidance, while at the same time responding to the concerns of the reporters at the SDP examination and learning the lessons from its implementation. Further work was commissioned over the summer to clarify the evidence base to support the review. This has clarified the link between all new developments in the area and all the proposed interventions, with one possible exception. In fact, there wasn't, in the end, one possible exception. This overcomes the difficulty presented by the way the evidence was previously presented, and it then goes on to talk about the difficulty about consultation. So further work was done, and table 3 in the appendix was the product of the further work.
But it is the same, isn't it, as MS 317, which is the updated table 7.2 attached to the cumulative transport appraisal.
Well, it deletes the lost in link and the fast link Elsick and uses different percentages because it's showing something different.
No, sorry,
Which pages are we comparing?
I see.
Table 7.2.
No,
let me be clear about it. Table
very helpful.
7.2 is a page, I'm so sorry, page 155, 155 of part 1, MS 283.
So we're comparing 283 with 317, yes?
Yes. And
they're hugely different, obviously. I was asking whether table 3, which is attached to, is the same as... I've now lost where table 3 is, but you can help me.
Table 3 is MS 158.
158, yeah. Yes. Table 3 is surely precisely the same as the revised
Yes.
Table 7.2.
The revised, I'm so sorry, the fault is mine, forgive me. When Your Lordship is referring to the revised Table 7.2, you're referring to the transport addendum, which is in Part 1.
Yes, I see.
And the transport addendum is at Part 1, page 1. 8.8. So,
Yeah, so
NS 296.
316.
316.
So it's an addition that to the CTA.
Yeah, well, it's an addition after some further work was done, and it was done in order to address the point about the concern about a link. And so instead of using the proportion of development traffic using new infrastructure, it now has the proportion of new development traffic using specified new road infrastructure. But it still leaves the authority in implementing the supplementary guidance, leaves the authority with the task in relation to a specific development and a specific Section 75 agreement of working out, if required by a developer who's made a contribution, working out that developer's contribution has been used on one of the Schedule 2 interventions which benefits his development.
Now, Mr. Kingston, we're reaching the short adjournment and pretty well the end of your time at how are we doing?
Slightly less well than I'd hoped, but I've got, subject to any further questions your lordships have, I'm almost to a very short summary of the legal position.
You've almost got there. Well, let's try and get there, and then you can do the short summary after the short adjournment, which no doubt will give you the opportunity to
even shorten it further. Well, I've fully understood that. So, my Lord,
I think in terms of timing, you may be eating into your half hour of reply.
Yes, well, that may be, and I must suffer that. What my learned friend's challenge must contend with is that the next point, that the supplementary guidance makes clear at paragraph 7.3 what contributions will be used for, and as we've seen from the Black Dog section 75, the authority can be held to account. And the final point, the process is an open one. See Appendix 5 of the supplementary guidance as we've just done. The First Division's opinion, my Lords will have read already, paragraph 32, is founded on considering the supplementary guidance and the lawfulness of it, on the proposition that it was to have regard to the terms of the circular. The respondent's written case suggests that because the supplementary guidance is part of the adopted development plan, and therefore applications are to be determined in accordance with it unless material considerations indicate otherwise, that they will be effectively obliged to make a contribution to the STF for reasons which we've just discussed in relation to paragraph 5.4, the opt-out provision. That is not correct. The opt-out provision at paragraph 5.4 is as much a part of the development plan as is the calculation of contributions.
Yep.
The First Division's criticisms of the supplementary guidance and the absence, they thought, of it following Circular 3 of 2012, the question of linkage is addressed by paragraph 6.1 and 7.3. Secondly, as to the criticism, there is the commitment to ensure that a linkage is maintained by an open accounting process of the kind we've now discussed in a little detail and I won't repeat, so that it ensures, that is, the supplementary guidance ensures, that the only legal requirement to make any Section 75 agreement a material consideration, that there should be some connection that is not de minimis, is maintained. And also I've then reached the point where we turn briefly to the law.
Well, then we'll adjourn now, and we'll resume again at 2 o'clock.
Thank you.
Thank you very much. Of course, now adjourned.